Hello, everyone. It is noon here in Cambridge, Massachusetts, where I am. So, time to say good afternoon, although I recognize that it might be good morning, good evening, depending on where you're tuning in from. Welcome to this edition of PON Live from the Program on Negotiation at Harvard Law School. I'm Nicole Bryant. I'm the managing director here at the Program on Negotiation. And often I start these discussions by explaining what PON is a research group here at Harvard Law School, but I'd like to start today by giving an example of what we do, because this is an exceptional week to be a part of the PON community. Yesterday, May 5th, we welcomed our newest group of masterclass executive education participants from all over the world to Cambridge, Massachusetts. I got to start my week by welcoming people back to campus for many of them to continue their negotiation training journey with us. After that, we had an event in the context of our U.S. Secretaries of State project, where we have interviewed every living United States Secretary of State, and we were honored to have former Secretary Mike Pompeo, who was the second Secretary of State under President Donald Trump during his first administration, come to campus and talk to us about some of his important negotiations and diplomatic insights with a group of our faculty and students. And later in the week, we're going to be uniting a group of our faculty for a pedagogy dinner to talk about negotiation instruction and best practices. So this is PON, executive training, events, and pedagogy all mixed into one. And then, of course, here we are today on Tuesday for a wonderful discussion with a colleague of ours from the Ohio State University, Amy Schmitz. And I will tell you that I had the great pleasure of meeting Amy in person here in Cambridge, Massachusetts in March, when PON hosted a summit on artificial intelligence and negotiation. We had about 200 participants from all over the globe coming to talk about this topic. And Amy was given the very unenviable time slot of being last on day one to present to this group. And I have to tell you, she absolutely lit up the room. And I knew at that moment that we had to invite her back to continue the conversation with our larger community. So you are certainly in for a treat listening to Amy today. She is going to talk to us principally about her book, The Arbitration Conversation, which is a series of insights that she developed from discussing with her colleagues from around the globe on different topics in arbitration, but also touch on an incredible project that she's been working on at The Ohio State University around justice tech. Hopefully we'll have time to treat both subjects, and of course to leave room at the conclusion of our hour for some questions from the audience. So if you have a question, please put it in Q&A at the bottom of your Zoom screen. This program is being recorded. If you need to duck out at some point, you will be able to view it on our website in probably a couple of days, or if you want to share it with a friend or come back to it for all of that. So please know that that will be there so you can view everything and Amy's slides. I have to give an extra special thanks to the PON team today. Pulling off all of these events in one week is just absolutely colossal. And Laura San Pietro has been leading the charge from our team, but also really with great help and effort from Diane Long and Riley Schretzel, who are both helping this event. It takes a lot to do all of this and get everything in order, and I'm so deeply appreciative of them right now. So without further ado, I told Amy the best part of my job is having really interesting, insightful colleagues come on and talk about the work that they're doing. So I will stop talking now and cede the floor to our guest, Amy Schmitz. Thank you so much for being with us today. We are absolutely delighted to have you and to learn from you.
Well, so first of all, I just want to thank you. I am so honored to be part of this. I love all of you, and I am so impressed with what you do and just all of the programming, and I'm just really thankful to even be part of this series. So thank you.
Thank you.
So without further ado, I will go ahead and get going. Oops, I went too quickly. All right, so I'm going to talk first of all about the book, The Arbitration Conversation, and then from there, if there's time, I will also touch on justice tech. Of course, both actually do involve technology. So the arbitration conversation, it really came out, it's really sort of a looking into all these interviews. I felt so lucky, talking about getting this opportunity to talk to people through this medium, right? Having this ability to do a podcast. And back at the very beginning of the COVID shutdown, I was having a conversation with my friend Colin Rule, and he had just taken over arbitrate.com. And he kind of said, well, we need content. Meanwhile, I just was moving all my classes from in-person to online over a weekend. And I thought, wow, how can I make my classes more interesting? How can I sort of inject new life into my arbitration and dispute resolution classes? And started a podcast and just started doing interviews with all of these arbitration experts from throughout the world. So I just want to begin by a huge thank you and shout out to Colin Rule, but also to all of the individuals who were interviewed for the arbitration conversation. In the end, I had 100 video interviews and then another 20 podcast videos after that when we moved from video to no video, which people actually really appreciated, not having to be on video. But then also kind of bringing in my own insights and research. And a lot of it really does consider technology. And this was a time capsule to see how individuals were suddenly using technology to a much greater extent than they had prior to the COVID shutdown. So the book, first of all, Colin Rule did write the foreword, and the preface is really the story, the lemons to lemonade. Obviously, it was an incredibly tough time, and many people lost their lives, so it was not a good time. But new opportunities to really discuss these issues, to think about arbitration. I am an arbitrator as well as teaching arbitration, and I like to think about it not only from theory, but also practice. And getting to talk to individuals who were experiencing how important it is to be adaptable as an arbitrator. And when I actually did the interviews and then I went back and I watched them and rewatched them and thought about what are the threads, what are the takeaways that I can get from this treasure trove of information. And the first thing that came to mind was just how you have to be adaptable as an arbitrator. It was really quite remarkable. Arbitrators, more so than judges because they don't have the same rules of civil procedure, right? And so arbitrators were able to be more adaptable during the COVID shutdown. But then it also allowed me to learn in other ways that arbitration and arbitrators can be adaptable. But then that brought me to lesson 2 in a chapter that looks at really how can arbitration be a tool in your problem-solving toolbox. I've taught a course called Lawyering and Problem Solving, and we think about negotiation, mediation, arbitration, and how they're different tools for different problems and different people. And that importance was another lesson learned. Additionally, context. In fact, I wish I could have had a separate chapter for all of the different contexts. One thing that's also very important is every time you are thinking about what is the best tool to use for this particular problem and these particular people, you have to think about it in context, right? Very different talking about employment and consumer versus intellectual property, construction, sports, international arbitration, oil and gas arbitration, environmental arbitration. So many different issues and contexts are discussed in chapters 3 and 4. Chapter 5, really shining a light on the importance of diversity in arbitration. That has been a challenge, and a challenge that needs more work, right? We've heard about the Ray Corollary Initiative and other initiatives in arbitration to really help with diversity, and that chapter really shines important light on an important issue in the world of arbitration. Then the book, now we're going to really move into chapters 6 through 12 and the conclusion, where I was really focusing on technology and thinking about my prior work in the area of online dispute resolution and AI and other data analytics in the world of arbitration, mediation, and negotiation. And in fact, it was really fun because during the course of these chapters, I talked to individuals who had never used any technology prior to the COVID shutdown, and suddenly they were in love with what I call OARB, online arbitration, thinking about how can we use that to lower the barriers to access, to increase access to justice, to make it easier for anyone to arbitrate using their cell phone, right? And we saw more and more of that, which continues to this day, and really moving it into the mainstream. In the course of these interviews, I also got to speak with individuals who've created new online arbitration platforms and new startup companies and individuals who are innovating and reimagining access to justice and creating very, very interesting processes. But it also shined light on the importance of practice, right? So if you are an arbitrator, if you are a party, if you are an attorney representing a party, you need to practice using these different technologies, these different tools in the course of arbitration. Of course, chapter 8, I did dive into the Supreme Court cases that came out during that time and more. There have been so many cases, and Congress has also put forth different bills like FSASHA, looking at sexual harassment claims, and those are no longer arbitrable, and what that means. And so getting a chance to talk to experts in the field was a lot of fun. And judicialization of arbitration is chapter 9. And I talked to many arbitrators and arbitral institutional leaders who talked about, it's important not to bring in everything from litigation into an arbitration. Again, going back to this idea of arbitration as a problem-solving tool, not a problem-creating tool, right? And so it was really insightful talking to new arbitrators, old arbitrators, new voices, diverse voices. That was also important in the arbitration conversation and my interviews. And the book does dive into that. Moreover, chapter 10, we're not just talking about Zoom arbitration. And that's important because in the beginning, that's all we talked about, right? You think about 10 years ago, weren't even doing a lot of that, right? And then 5 years ago, even, it was more, okay, we can use Zoom for arbitration, but now we are opening up a whole new world of AI, data analytics, and even blockchain. One of the chapters really is delving into talking with Claros. I know Claros has presented with PON events before as well. How can you use blockchain in a dispute resolution process? Moreover, where does blockchain matter for security and securing a process? And of course, AI. And that really creates new ethical obligations. And there is where I really spent a lot of time and the conclusion in going forward. In the next slides, I'm going to delve into some of these issues focused on AI. There's so much to cover in this book, and I'm so happy and thankful for an opportunity to talk with you, but I'd like to get this focused on the AI aspect, which of course is larger than life. So first of all, it's pretty exciting. In fact, I really loved the event in March because I got to be on a panel that talked about AI as coach, right? How can we use agentic AI? How can we use these different AI tools to help parties and counsel and arbitrators, right? You can really assist self-represented litigants, access to justice. Even some AI tools like natural language processing don't get enough love. They can be really helpful in a lot of different ways. Translation, for example. Strategizing. We're seeing more and more use of AI being built into platforms and this ability to use it to strategize, to be smart about our ZOPA, right? What is our zone of potential agreement? And a lot of arbitration actually does involve negotiation because most arbitrations actually end before the hearing. Why? Because the parties negotiate and reach an agreement before they get to the arbitration hearing. Speeding up, document review, digesting e-databases, examining agreements to find out quickly and at a lower cost, by the way, if the arbitrator, for example, is charging by the hour and now can work more quickly. Same with counsel. One of the interviews I did was actually the founder of Arbitration Intelligence, which is really interesting in looking about the use of AI in arbitrator selection. And in talking to Catherine Rogers, who developed Arbitrator Intelligence, it was cool to learn firsthand in that interview, and I talk about it in the book, about how they used AI in collecting and providing insights for selecting arbitrators, because that is the most important aspect. Counsel, I remember when I was in practice, that was really important. Choosing the right arbitrator who has the right expertise for the particular case is important. We also see kind of in international arbitration, it's particularly important. Why? Because first of all, you may not know or have easy access to the information you need to learn about the arbitrators. So Arbitrator Intelligence, for example, includes an AI-driven platform to really provide data-driven insights, not just a gut check on, oh, I like this person and always going with the same person, but opening up for diverse arbitrators by learning about their expertise. And that might be the right arbitrator for this particular problem and these particular people. But it raises ethical considerations. And throughout the book, I raise these ethical considerations. First of all, there's some concern that some research have raised regarding bias, right? Because sometimes actually the AI can bring on new bias toward the arbitrators that have more experience, meaning new arbitrators don't get an opportunity. Accountability. We do have to worry about anchoring and confirmation bias, which I will talk about shortly. We also see these new developments with the American Arbitration Association, ICDR. They have this new partnership with ClearBrief AI. Some of you in the audience may have actually played with it or seen how it works, because if you are an arbitrator, you have access to ClearBrief AI when you enter the portal as an arbitrator. Now, that can be helpful, right? To provide summaries, to sort of speed up fact checking, maybe to lower the amount of time that you spend and therefore the amount of money that you charge. But there's some concerns there, which we will get to later. And that makes it even more important to be accountable and transparent in your use of AI as an arbitrator. Because here's my shameless use of alliteration, which I like to do at all times. There are dangers of digitizing due process, and there are the dangers we have to think about. And certainly in the book, I go into these with the ethical considerations and thinking about, yes, can you improve efficiency? Could you improve access to justice? Is it smart? Is it the next wave? Is it happening? Yes, but we have to be smart in the way we use these tools. First of all, it's not just a fact that, yes, we've all heard about how these different generative AI tools and even RAG systems, they might have certain biases baked in because of the data itself, right? Garbage in, garbage out. We've heard that discussion, but I like to add the human plus AI concerns. Because first of all, as humans, we have an anchoring bias. So if you hand me something and I'm the arbitrator and you say, here's the AI analysis of all the documents, and here's what the AI says, am I going to be anchored on that, or am I still going to use my independent judgment? Am I going to be using it otherwise for confirmation? Confirmation bias is also a human propensity. Whatever we do, we try to confirm that it was the right decision. So how might we manipulate data in order to confirm what we are doing and maybe to allow for us to act in ways that are biased? Explainability, we've heard a lot about that in terms of hallucinations, and sometimes it's not perfectly explainable how AI has come to a particular prediction. Now, I would argue that it keeps getting better and better. It's really quite amazing. Many of you, I'm sure, have played with these different AI tools. And of course, the paid versions are going to be better. And we have law firms that are creating their own robust closed systems that are more secure and are trained on legal data. So it is getting more accurate. But often there's still some explainability issues with Justice Tech. In fact, I work directly with computer sciences, and it's amazing to really look under the hood and see how these systems are built. And there can be coding errors. There are a lot of things that can cause problems when you are building these different systems using technology. Additionally, there are IP reasons why we can't get at the secret sauce, right? No one's going to give us their algorithm outright. And so sometimes there are proprietary blocks that stymies transparency. I would also argue that, especially in my research, I like to sort of follow the money. And so I look at how much money is going into these different AI systems. And you sometimes wonder, are they a little half-baked, right? Are you sort of rushing? Do you have enough data? Are we really considering all the data that needs to be considered? Is it properly structured? One concern I often have in the world of negotiation, arbitration, and mediation is that if you're only looking at data from reported decisions, those are outliers, right? Most decisions, most cases, most problems are resolved through arbitration, mediation, negotiation, and that data is private in most cases and is often not involved and not part of the model. I would also argue there are other dangers, and especially I even think about this as an arbitrator. AI has limited capacity. The data has limited capacity. Often, really what somebody wants, many of you are mediators, you know, they want to vent. They want to talk about it. They want to get it out there. They want to have a reason to meet, in fact. That is one of the drawbacks of OARB or online arbitration, because having in practice really represented a lot of parties in arbitration. And a lot of deals are made in the hallway, right? And we call it a settlement event, showing up for the hearing. Those might open up opportunities for really developing a win-win. So just relying on the data, maybe a bot arbitrator has limited capacity. So it's really important to think about, what are your goals as individuals? What are you looking for? Again, going back to my sort of theme, which is thinking about it as a problem-solving tool, considering the goals, considering the people involved. Transparency, often we need transparency. Well, we do, especially for due process, so that you can trust the process, trust what is occurring. And there's some concern that, well, do we know, are arbitrators starting to just rely on AI, or are they still using that independent judgment that they are required to use? I also worry a lot about unequal access to AI and these different technological tools and gaming the system. It's interesting, and it's still a problem, by the way. Access to the internet in general is still a problem. But now we have this whole new thing, right? Large law firms with the best and brightest and most robust technologies out there, they can do analytics on everyone, on opposing counsel, on the arbitrators, on judges. And yeah, I also worry a bit about this idea. Yes, is it possible that robo-justice or bot arbitrators could be helpful in certain low-dollar claims where everyone agrees that that's what they want, quick, fast, and cheap? But does that mean that you're going to give sort of this second-class justice or second-class process, if you want to call it that, to particular individuals? Again, we have to think about optionality. We have to think about allowing people choice, considering their goals. So on the same front, and it's discussed again with the ethical concerns, the AAA ICDR actually has come out with guidance on the use of generative AI. And number one, it is important that that arbitrator still checks the accuracy of the information. So it's very tempting, right? You go into the portal and you can just click, I want to just use a summary from ClearBrief. But it's still up to you as an arbitrator. The buck stops with you to ensure accuracy of that information, which begs the question, are you really saving time, right? So if you're using the summary, but then you're going back to read all the documents to make sure it's accurate, have you saved time for the clients or not, right? So we have to think about our use of AI and always remembering that we have to check the accuracy of the information. Confidentiality, that is a very big issue. It is true, especially in the early days. I remember talking with a group of arbitrators and sort of asking by show of hands, how many of you are cutting and pasting and putting information into ChatGPT? And they were, right? And you're like, wait, it's called open AI, meaning it's not confidential. So you have to consider the tool and how you're using it and ensuring confidentiality of that information. Very important under the AAA rules. In fact, confidentiality is included in arbitration. Competence, really understanding the limit of these tools. Under the ABA rules, in fact, professional responsibility, the duty of competence includes a duty of technological competence, which means that you understand the benefits and risks of that AI. Preserving fairness, thinking about, what do you do when you are a neutral and you know that one of the parties, for example, has access to the biggest, brightest, most robust and fierce technological tools and the other doesn't? What do you do about that? How do you make sure that fairness is maintained? And delegation of decision making. This one is huge because there is a lot of concern out there that people get lazy, right? And are they going to just rely on an AI tool to write a decision to get it off their plate to do it quickly? Be careful with that, right? Again, arbitrators, you cannot delegate your decision making authority. Really, the ethical duties, I sort of crystallized them in the book. And in fact, I was part of the ODR task force for the American Bar Association section on dispute resolution. And these were really the big pillars in terms of the ethical duties for online dispute resolution in general. And this includes negotiation, mediation, and arbitration. So first of all, accountability. It's really important when we think about our use of technology that we remain accountable for what we're doing. What is the tool? Is it the right tool for the problem? What are the limitations of that tool? Transparency and explainability. Letting the parties know if you are using some sort of AI tool in a way that they might not approve of. Now, they may approve, they may ask you to use it. Recently, I was moderating a panel of practitioners, and they were saying that actually their clients are asking them to use AI to be more efficient. Okay, you're being transparent and being explainable in terms of the actual tool and how it's coming to its decisions and understanding what it is trained on in terms of the data itself. Getting back to the equal, fair, impartial, really important, especially as a third-party neutral, you must maintain that equal, fair, impartial throughout the process. Finally, privacy and security. Again, we don't give enough love to privacy and security. One thing I've learned in the Justice Tech program is how important really creating systems that are private, secure is so important, especially where you have data that is confidential, that is really important to maintain that privacy, that security. So in terms of future directions, I always like to make sure going forward, and I talk about this in the conclusion of the book, is really thinking about, you know what, it's not going away, right? We know that. So how can we really enhance efficiency? How can we use AI and blockchain? How can we reimagine access to remedies, access to voice, access to justice? Ethical and regulatory challenges, thinking about what is an ethical way of using this AI? What are my concerns, and not just thinking about efficiency? Of course, as we all know, any law professors out there or lawyers, you're constantly balancing efficiency and fairness. And it is absolutely important that you don't sort of ignore fairness for the sake of efficiency. And really predictive analytics and bias prevention. So thinking about how can we actually use technology to mitigate bias. A good friend of mine, Nicholas Vermey at the Cyber Justice Laboratory, he always reminds me, it's like, humans make mistakes, right? We have many studies out there where, sort of what the judge had for breakfast can help determine an outcome. So maybe we can use AI to help sort of balance that, to check ourselves as arbitrators, not to just go with it, right? But to take it seriously in order to check ourselves to be sure that we are not acting in a way that is biased and that we are considering the data and remaining accountable as arbitrators. I also think we're going to see more and more of these sort of agentic AI and use of sort of real-time legal assistance, but it's still important to remain that data privacy. I think that that's going to continue to be an issue on privacy, and I hope that we pay attention to that in all of the tools that we use, and certainly in the world of dispute resolution. And to be creative, right? How can we actually use metaverse? I talk about it in the book. And we have an example in Colombia where they use metaverse for a case. New directions, new opportunities out there. It could be a safe space for someone. Other individuals may want a blockchain-based arbitration program. And programs like Claros have really sort of opened up new avenues and new considerations in blockchain arbitration. So takeaways on the book and takeaways in my remarks. First of all, I like to say technology, it's a tool, again, along with arbitration. It's not all good, it's not all bad, it's how you use it. You don't use a hammer when you need a screwdriver. And I think as arbitrators, as parties, practitioners, you have to think about what is the right tool for this particular problem. And out there's some really good charts and good analysis that is happening that looks at, the different tools and how they are better at certain things. And that's really important for us to consider as part of our ethical duty. Again, the duty of technological competence to understand the benefits and risks, because ethical use is essential, and acceleration is going to continue. And I really think that we have to be smart and consider foundational ethical concerns every step of the way, so we don't get sort of caught up on the shiny new toy. Really important on that aspect. So it looks like I have about 10 minutes. Is that right? If so, I might talk a little bit about Justice Tech before I pause to get questions. So Justice Tech is my new program, which really does build, yeah, I know you're sort of like, wait, whiplash, we're talking about arbitration, now we're talking about Justice Tech, but they are related. Because the work with the arbitration conversation and in analyzing AI in arbitration and mediation, it really made me think about what if students, law students, computer science students could work together to really see in practice ethical AI to assist access to justice. So AI enhanced online dispute resolution systems. So what we are doing is we are designing, building, testing systems that are focused on areas of extreme need for access to justice, but with ethical AI at the core and continually gathering data so we can inform policy in these areas. The key areas that we're looking at are eviction and truancy, and more areas will be on the way. So a little short primer for those of you out there who aren't sure what these are. So eviction, the way it works in Franklin County is you miss your rent and you get sort of a tag on your door, and you are supposed to go physically down to the courthouse, which is very hard to do. And you often really don't even know your rights and you don't know what you can do. And so you don't even go to the courthouse, and then you are evicted. You get a set out. Once you have an eviction on your record in Ohio, it is very difficult to get another apartment. So we are building and designing an online dispute resolution program to help tenants and landlords mediate and negotiate a settlement for staying in the apartment that works for both sides. And moreover, we're doing it pre-filing and online so individuals don't have to go to the courthouse. We are including AI to assist in helping the tenant, helping them learn about their rights, also learning about resources out there. What we learned in our empirical research is that it's really important to think about all the resources that might be needed for that tenant. It might be that food insecurity is a problem. Well, if they have more money for food, then they have the ability to not only feed themselves, but then more money frees up to pay rent. So considering holistically and having calculators built in is part of the process there. On the truancy side, again, thinking about AI as coach to really assist individuals who are self-represented in these cases, because the way it works in Ohio is that if your child is missing for a certain number of days, you get a summons to go to court. You get fined. You can even get jail time. That's not problem solving. So instead, we are helping to design and build an online platform for online mediation that can bring together the school and the parents and the court officer in charge, but also a third-party mediator to help problem solve around why is the child not going to school? How can we help find what is needed? And that, of course, includes a portal where it is a decision tree analysis where a parent can anonymously, and that's where the privacy and security really came in, is anonymously go on and find transportation, find access to learning. Maybe there's a problem that the child is having. Maybe there's bullying happening. So really thinking through sort of the different resources that might be needed. So I will go ahead and stop share and take questions because there's a lot more I can say about Justice Tech. But everybody has access to the slides, I hope, through this, and I welcome you to check those out and feel free to ask any questions that you might have. So I know I covered a lot of ground there, but hopefully I didn't go too far over in terms of time.
You did not at all, Amy, and thank you so much for your thoughtful presentation. It's no wonder, I'm sure that everyone will agree with me that you were recently awarded the ABA Dispute Resolution Sections Award 2025 Award for Scholarly Work at the Chicago Conference last month. So we are so delighted to have this conversation, and we could have kept going, and hopefully we will through the question and answer. So everybody, please go ahead and put the Q&A. Put your questions in the Q&A. We've already had a few. So let's start with Jude, who wants to, going back to the arbitration conversation, could you please discuss the role of blockchain technology, especially given its controversial background for enhancing client-sensitive arbitration?
Yeah, no, thank you for the question because it was sort of a journey. That was back, oh goodness, I guess about 5 years ago where I, started talking to Federico Ast and learning about Claros. And so Claros uses blockchain for secure voting. So token holders who basically are within Claros can vote on the outcome of these cases. Now, I agree, there's some ethical concerns there, but what they are doing is continually gathering research and making sure that there is not collusion, and that's been really important to the platform. The idea as well for Claros is this really for secure decision making, because I agree. I remember actually I taught at University of Colorado for 16 and a half years, and I remember I learned about cryptocurrency there because it was used for money laundering, right? So blockchain does have sort of a not so great past, so I appreciate the question. But I think what companies like Claros are doing is they're trying to think through, well, how can we create a secure system that can quickly and cheaply help provide resolutions? And they're even creating expert panels that then are allowed to vote on these particular cases in order to make sure that it is ethically sound. And I actually just saw Federico at a conference and asked sort of, what their newest areas are. Insurance is an area where often a quick remedy is really needed, and having the right people with the right expertise is important. Another area where it has been used, and I had an opportunity to sort of sit down with their CTO and see how it works, which was really fun, was to decide questions around whether or not a cryptocurrency was fraudulent and should be taken off of a platform like Coinbase. And if you have experts who actually understand blockchain making those decisions, that's a good idea, right? Because you do want experts making those decisions. And a generalist judge may not even know what blockchain is, right? And so it's actually really vital to have somebody who understands the industry and understands when something is fraudulent. So, and then they do have appeals processes built in. And so, it's really experimental, yes, and controversial, yes, but interesting, right? And how another aspect is smart contracts. So another area where we've seen blockchain used within arbitration is, for example, in international arbitration, where otherwise you'd be using very expensive letters of credit and other mechanisms, but using a smart contract for automatic payment can help build trust. So really, blockchain is a way to build trust, and where it's coded for automatic payment when the goods, for example, arrive and they're unhindered and they're good. And if the money changes hands automatically, that can actually be very helpful. And it's also been really popular in a lot of other parts of the world where maybe the actual, what they say, fiat currency is maybe not as trustworthy as cryptocurrency. And so, yes, is it controversial? Yes, does it have problems? But yes, it could have promise in particular areas and is certainly an interesting area to study.
Wonderful. Thank you so much. Um, we have a question from Patricia about any examples or discussion of arbitration in the telecommunication and broadcasting industries
Oh, I
specifically.
love the question. Yeah, no, that's a great question because some of my interviews actually uncovered these really niche areas. And I'm going to go back to the expertise. One thing that really came out of the interviews loud and clear: individual parties want an expert in the field. And so in the telecom space as well, you can have an expert. And the AAA and others, they create panels with experts where you have to show that you have background in that area. And your resume has to show that you actually have background in that particular area. And we're seeing more and more use of arbitration in telecom, in IP cases, in technology related cases, because of that importance of having an expert who actually understands. And I have to say, as a former, representing parties in arbitration back when I was in practice, that was so important. Often we would have these very technologically, just really intricate cases where, you need somebody who understands the blueprints, who understands the coding, who can really understand what the problem is and help to create an accurate outcome. And so I think we are seeing more and more of these specialized tribunals in arbitration. And I think parties are asking for specialized arbitrators who understand these questions.
Lovely. Thank you so much, Amy. A question, you've now spoken to hundreds of colleagues across the world about their experience through the course of the arbitration conversation. What are some of the things that surprised you the most as you encountered these? Are there divergent viewpoints, whether or not you agreed with them that you would call out that you've heard?
Yeah, first of all, I love, yeah. It was one of the sort of most fun things was I would do like a pre-interview oftentimes and talk with someone who I've never met before, right? And you're talking about all different things, and people were so generous with their time, especially because we were all stuck in our homes, you know? And so, and you would have these amazing conversations with people from all over the world, and certain things that never made it on camera or never made it part of the actual podcast. But I learned some really interesting things. Number one, I talked to individuals who were only mediators or only arbitrators. And I think I naively thought, oh, I think there's many individuals who, most neutrals want to do both mediation and arbitration, and that's not true. So that was really insightful and helped me actually as a teacher in understanding students in simulations. And now I've talked to students where, they'll take the mediation clinic and then they'll do an arbitration simulation. And some will say, oh, I just cannot stand mediation because I just want to tell people what to do, or vice versa, right? And so that was one insight that I learned is sort of different people have different personalities for what they're best at, and to know themselves and know where they're better, maybe at mediation, maybe at arbitration, but maybe not both. Number one. Number two, it was really insightful. Some individuals were very clear on they would rather wait until they were not going to have online arbitration under any circumstances. They were very distrustful, sure that there's someone hiding under the desk or that people are being coached. And even if you pan the room, you're using your camera, you don't know for sure whether somebody's truly by themselves. So concerns about that, concerns about the credibility of any sort of an online process, concerns about privacy, especially as we were hearing about Zoom bombers and all of that. So I think that was eye-opening, where I sort of assumed everybody was kind of okay with using even Zoom, but I learned that actually that's not true. So that was really interesting. The other thing I really appreciated, there was one arbitrator in particular, and that was really eye-opening, talking about just the evolution from when he first started like 50 years ago as an arbitrator to today. And I felt like that was also really sort of surprising, and I wasn't expecting that. And also I interviewed a lot of sort of startup, different online dispute resolution startup founders. And one of the really important, you always think like, oh, they're all excelling, they're so excited about it, but also it is so tough. And one of the founders said, creating a startup company in online dispute resolution is like chewing glass. And that was also like a really good, oh, wow, yeah, this isn't easy. It's a tough market and there's a lot of competition. So those were some of the big kind of, wow, that was interesting. I
Yeah.
didn't expect it. Yeah.
Yeah. Well, I love that chewing glass comment. And I'm thinking, for a lot of people, and I'm not, it could be young, old, experienced or not, this is a paradigm shift. And so I'd love to know, as somebody who's kind of, had these conversations and also an ambassador, I would say, for the use of technology, how can we help our colleagues to get on board, or judges, or, everybody who's involved in this work? What is the best way to do that? And I guess to learn in a continuing education setting as well as a university setting about how to take on these technologies.
I really love that question because I struggle with that one, to be honest. I mean, even as all of us who are within an institution, there, you can have colleagues who understandably are very against any use of technology and really focused on all of the negatives, which there are negatives. I'm not going to lie. Yeah, we have to think about that. And so I think number one is to really open up those conversations and have those conversations with colleagues, with individuals. What are your concerns? How can we think through responsible use of technology and make that foundational in any use, in any way that we use it? And we're not just rushing to assuming that it's good or that it is providing an accurate or efficient result, number one. Number two is playing with it and creating simulations that forces people to play with it. That I think has been the most kind of eye-opening, is when we've been doing that actually at Moritz, is having simulations with the faculty and with students where they're actually having to use it, right? And then they realize, oh wow, and starting with baby steps, right? Like, okay, use AI to create a packing list for your next trip, or to help you create a PowerPoint organization, or to help create a list of questions to ask in an interview, right? So things like that, where it's low stakes, I
Yeah.
think it helps people feel more comfortable and then think through, okay, maybe this is how it actually could be helpful to me, but then not become too reliant on it as well. And I think that is also important. But yeah, I think, testing it out, playing with it, seeing where it's useful and where it's not useful. The other thing I think is really important is to give people space and grace on that, because um, different individuals have different sort of propensities and what they want to get out of AI, and really focusing on how can we use it to augment human intelligence. I know that sounds kind of cliche, but I do think that's important, is thinking through, we're not talking about overtaking human intelligence, but we're talking about how can we augment human intelligence and do more with less. We're even seeing legal aid realizing, wow, this can really help us. And I think that that's an important aspect to it.
Yeah, wonderful. We have a couple of questions on Justice Tech, so I'm going to pivot,
Awesome.
and I know
Okay.
we dedicated a little less time to it, so we may be able to be more expansive as we talk about it. One of the questions is, what you're doing seems to be such a wonderful lab, and I was so struck by the impact you're having on the Ohio community. How can we scale this? I think there are people here who may say, I would love to bring this, to my
I love
community.
that. No, so
How can we
actually
make that
one
happen?
of my, no, that's a great question, and something I think of all the time, because right now, kind of in the context matters and starting off, we would like to, well, we're starting with these pilot projects so we can design, build, test. So for example, this summer, we're doing actual research, UX, UI, and also really diving more deeply into the technologies created to make sure, where are the bugs and how can we better develop them in the next semester, because the class under the grant that we have, well, we have 3 grants, and one of them, so we teach it every semester so that you can build on and improve the process. So some of the work the students are doing is actually redesign based on the research over the summer, number one. But number two, I like the question on scale, because what we are also doing is one of the grants is with the AAA ICDR, and what the deliverable under that grant is to actually create a guide. So we are creating an open access guide that will be coming out in the next like 2.5 years, because we want to really make sure that we have a proper sort of blueprint for other universities, other institutions that are interested in doing this kind of work, because we're getting a lot of lessons learned. Because, for example, anyone on this call knows that it's really, and PON does this as well. It's hard when you do interdisciplinary, cross-disciplinary, you're working with different departments, with students from different backgrounds. And it's really important to embrace that, though, because I think it's good for the pedagogy and good for learning, but also to develop best practices on how to best do that. And so we're really working on that. And in terms of scale, we're thinking about new partnerships and partners. So for example, on the truancy front, we're thinking, well, how can we partner actually with Progress Book, which is the technology that is used by many schools throughout the country on tracking attendance, so that we can help triage and build an online mediation earlier, right? And so that would help scale it. And also we're using open source for everything. So meaning that as we develop and as we move further and we work the kinks out, it can be usable for others that are interested in these kinds of projects.
Yeah, wonderful. Great. Thank you. Well, a question to to the teaching nature and the pedagogical nature of leading Justice Tech. How do you find, so you're working with law students and computer science students? What is that interdisciplinarity process like for you? And, how have you found, has there been, a lot of enthusiasm? I mean, now I'm sure that it's taking off a little bit more, but, for other folks who want to consider bringing those two types of folks together, what is some advice that you would give to other teachers who I know that we have on the call?
Oh, I love that. Yeah, and in fact, it kind of came out of my mouth when I was in Chicago, and so now I'm going with it. But the 3 R's, right? But I think number one is relationships. So when I first got to Ohio State, I started working with the Translational Data Analytics Institute, which is like multidisciplinary hub that looks at AI and technology from public policy, psychology, sociology, law, computer sciences. And so building those relationships was really important to then thinking about how we could partner and collaborate on this course with computer sciences, number one. Number two is resources. So then you get going on applying for grants, right? Because people let you do things when you get a grant. And so one of them was from Ohio State. It was internal. They had a competition on campus to go from good to great, and this was selected. And as part of that grant, the idea was to be multidisciplinary, to include 2 different departments at least. And so that was really helpful to kind of get it going, because now you've got resources, which allowed me to hire a staff attorney, allow computer sciences to hire an instructor. And then we were all able to start designing and building the course. Next, red tape. Being willing to sort of deal with red tape, because as anyone on the call who works at a university knows, there's a lot of red tape, okay? And trying to figure out, how do we kind of get around, okay, we need 2 course numbers, for example. You can't have 1 course number, you need 2 course numbers, because the money and how it flows goes with that, right? So the computer sciences enroll under 1 course number, law enrolls under another course number. But also in sort of designing it, it's important to constantly be checking in and collaborating with your colleagues in the other department. Building, for example, a glossary of terms that we provide to the students, because they think about fairness, for example, in different ways. Computer science, they talk about APIs, they talk about, Ruby on Rails, and then all this other stuff, and the law students are like, what? And the law students talk about due process and privacy and the GDPR, right? And so really helping them kind of learn from each other, but also team building. So what we tried to do is we created 4 teams, and it's project-based learning where the students work in teams that include 2 to 3 law students along with 4 to 5 computer science students. And the law students act as general counsel. And so they're getting really good experience of what it would be like to work with software developers, right? And to be constantly advising them on privacy, on drafting waivers, on information exchange. So, those are sort of the big pieces that I would say are really important, and that it takes time, right? I mean, this was 3 years in the making before we finally launched.
Yeah, yeah, absolutely. Well, I will say one of our questions that I will probably connect you privately on in the Q&A is if someone can join the team, and, a student from Mexico who would love to be involved as a capstone. So you're already getting more signups, including international ones, just from
Yeah, yeah, no, in
just
fact, I was just at a conference and talked with a colleague, international colleague who has like a lab, and we're gonna have a conversation. What if we can collaborate somehow amongst our labs? Like, I think that would be really fun, and thinking about this from a global perspective, right? That's one of the cool things about, having things like Zoom, right? Is we can really work together, international front, and learn from each other. And that's what I think is super exciting.
Yeah. Yeah, that's great. So, okay, Sahini, we just put Professor Schmitz's contact information in the chat. So please look at it and go ahead and contact her to see if you can join on board. We would love that for you. We do have a question about, these are cutting edge projects. They're using cutting edge technology. Are there some technological gaps that you are still confronted with, in doing this work, and what are they, so that maybe some of the brain trust that we've got here can start to work on it,
Yeah.
and
Yes, in fact,
work
I
in
would
the
love it,
space.
because one of
Yeah,
the biggest things we're starting to come across is we do need more research. Like, it's really hard to do it without a budget for the technology itself, right? And using all open source has its own issues, right? And especially when you think about, any of the intellectual property, and then who's going to own it, if there is even anything that's. So there's a lot of sort of legal issues that come in when you are using these different open source tools, and especially in areas where you have sensitive data, because of course with the truancy, we have to work with FERPA and other laws around data that pertains to children. So there's a lot of sort of legal issues that we are wrestling with, which has been really eye-opening for the students to see in practice, for the law students especially, as well as computer science students, because often they just think, well, we can build whatever we want. It's like, well, no, not really. You have to be careful with that. So that's one thing. But the other really big problem, I would say, from a technology aspect is, how do you then transition it over to whoever is going to maintain it? We are building it, designing it, testing it, but then ultimately turning it over to the client. The idea from the very beginning was that we are doing this for free, but they are donating their time to work with us, the clients, the self-help center, the school district. And so we would like to turn it over to them, but do they have the resources? Does it talk to their system, right? So it's very important from the beginning to have those conversations and to talk with their IT department, find out how is this going to actually work with the current system they're using, whatever it might be. And that's been really important. And in fact, led us on the truancy side to use an executable, which means that it doesn't need to talk to anybody's system, but we're still struggling with, okay, who is going to then maintain it? Because we can't do that as, you know, university kind of forever, right? So I think those are big sort of technical problems that exist. The other really big one that it's a lesson learned, and next year I'm going to be more vigilant on this. Find out exactly what the computer science students are capable of doing. There are things that I think we assume they could do that they actually couldn't do. Because remember, they are seniors. They are senior computer science students that are in their final, you know, capstone to graduate. But they're not graduate students, right? And they're not professional software developers. And that's why sometimes actually working on these kinds of projects is also like chewing glass because you find out that it's tough. It really is, because, you know, a lot of the programs that exist at other universities, they actually do have software developers building it, or they have PhD students building it. And we're kind of going out on a limb here to not have that, right? And so I think it's really important from a learning perspective, and I saw huge growth, especially amongst the students, in learning how to communicate with one another, but it's a challenge. So I would say that is another technological and really technical challenge.
Right, right. Absolutely. Wonderful. We have a question, and it may be our last one. We'll see, depending on how quickly it's answered, about arbitration. And the question is kind of simple. Do we need it now more than ever? Do you
Yes.
feel maybe
Yes,
kind of
full
leading?
stop. Yeah.
I was ready to. All right, well, we're done. We can ask another question. No,
Yeah,
but
no, but I
expand.
really do. I think for so many reasons, right? It actually is really important that you have. I was having a conversation with someone from another country actually, and just talking about how important, especially international, just having an arbitrator who understands the issue. They've been vetted, they've done the training. Anyone out there who's on, for example, the AAA ICDR panel or ICC panel or JAMS, they know that you don't just get on the panel, right? You have to go through training, you have to be vetted, you have to have experience, you have ethical duties. And parties really appreciate that. And, you know, even though you do end up in most all cases now paying the arbitrator by the hour, it can be so much faster, right? And so much more flexible. In the arbitration conversation, especially talking with other arbitrators. And I've always thought this because I also have a casebook with Stepanowicz on arbitration. I've always thought, you know, it's your process. The parties get to design the process they want. That's really important for a matter of like satisfaction and due process, right? Like deciding this is what we want versus just following sort of whatever you get from a judge, and especially generalist judges. They're not going to be as, I mean, nothing against them, they might be great, but in terms of understanding the particular issue at hand. And so yes, I think yes. And
Yeah, yeah,
we can,
that's
you know, think about the values that we want too, right? Like there's a whole thing on green arbitration and how we can help the environment through using technology, right? So anyway, I just think it's sort of exciting and a little more flexible, if you will.
yeah. Yeah, it's great. The program that we're teaching right now, Jared Curhan is actually currently teaching on subjective value. So this is very, you know, this is very timely, because I think in arbitration there is a high subjective value in being able to design the process and have, you know, have that impact. So, all right, with that, we are getting to concluding time. So I will say apologies to everyone to whose questions I wasn't able to answer directly, but let's please, you have Amy Schmitz's contact information. Please feel free to address them. Amy, thank you. What a wonderful hour spent in your company. Yet again, and so delighted that you took the time to be
No,
with us.
I want to say a huge
To all
thank
of our
you,
community.
but
Oh,
truly your
oh,
team
you're
and
so
everyone, truly thank you, thank you, thank you, thank you, thank you.
Thank you very much. Well, really, a meeting of like minds, so we're so grateful. And to everyone in the community, we have two more events before we wrap up our spring semester of upcoming events. Alexander Vaucru here to talk to us about Ukraine on May 13 and the state of the conflict there, which is ever evolving, of course. And then we always round out the year with our PON graduate research fellows. So our 3 fellows who are concluding their graduate fellowships with us are going to come and present their work, new findings in the field. We always love to have them on. So Mayron, Jameson, and Kenneth will be with us at the end of the month of May. Thank you to everyone. Once again, this recording will be available in a couple days on our website. So if you wanted to check out the slides or anything else, please do that. Thank you again, Amy Schmitz, and to the PON team, and we hope to see you soon. Bye.